Hey guys, this is the last video in the series on how to draft an employment agreement. So today I'm going to go through the boilerplate provisions. What are boilerplate clauses? They're essentially standard general clauses that are included at the end of every agreement. So first things first, you should always include a no waiver and no forbearance clause. What does this mean? It essentially means that if the employee does something bad, a breach of the contract, and the company does not take any action against him, it does not operate as a waiver or a forbearance. That means the company reserves the right to take action or to fire him later on. Number two, it is important to get the employee to represent and warrant certain factual matters to the company. What is a warranty? A warranty is essentially a statement of fact that is true. So, you have to get the employee to represent that he has the power to enter into and to execute the employment agreement. The employee should also represent and warrant that the employment agreement constitutes his valid and binding legal obligations. Number three, the employee should also warrant that the execution, the delivery and performance of the employment agreement will not contravene any existing law. That means by entering into this employment agreement, he will not be breaking any laws, which could include employment laws or whatever laws. Or entry into the agreement will not result in any breach or default under any other agreements. For example, he could have a bond agreement or a previous employment agreement which would be breached if he enters into this employment agreement with your company. The employee should also warrant and represent that he is not a bankrupt and that he has discharged all legal obligations under all present and past work engagements, contracts, education, bonds, and guarantees. There should also be a severance clause. What is a severance clause? It essentially means that if any part of the employment agreement is found to be invalid or unenforceable, it will be deemed to be deleted, but the rest of the agreement is still stands. It still remains. The rest of the agreement still stands as it is, with the provisions deleted. It is also important to include a governing law clause. If the employee is a Singaporean and the company is a Singapore company, naturally you want the employment agreement to be governed under Singapore law, and that the parties agree to submit themselves to the courts, the exclusive jurisdiction of the courts of Singapore. If the employee is a foreigner, you might want to state that the employee submits to the non-exclusive jurisdiction of the Singapore courts. That means there could be a choice for another foreign. For example, if the employee absconds to Australia, then you can sue him in Australia. So it will state that the parties submit to the non-exclusive jurisdiction of the Singapore courts, but this employment agreement may be enforced by the company in any court of competent jurisdiction. So using the example that I mentioned previously, if a high salaried employee commits a very serious breach of the agreement and then he runs away to Australia, by using this clause that the jurisdiction is non-exclusive to Singapore and can be enforced in any other competent jurisdiction, you will be able to enforce this employment agreement in Australia, whether by suing him in Australia or by getting a Singapore judgment and getting the Australian High Court to recognize the Singapore judgment. So thanks for watching this series on how to draft an employment agreement.